right, welcome to the Litigation Psychology Podcast, brought to you by Courtroom Sciences. Dr. Bill Kanasky, special guest on site, very unusual, coming at you from Birmingham, Alabama. Hence my Forrest Gump reference. Alabama, with Mr. Paul Motz, trial attorney, Chicago, Illinois. Are you surviving here in the South?
I am. It's actually remarkably pleasant.
After a full day of trial prep with a corporate rep, went well. Case has headaches, but what case doesn't, Paul?
That's why they pay us the small bucks.
Yeah. So today, this is going to be a down and dirty podcast. We happen to be together, and you haven't been on the show for a while.
No, I haven't.
It's been a while.
I thought you lost my number.
You were on our episode 100, by the way.
I know.
We're approaching 250 very fast. But I'm going to call this episode. So I'm going to interview you. I'm going to call this episode "Fact or Fiction," because I always hear these things from trial attorneys and claims people that say, "Oh, this always happens and this always happens," and all these very extreme statements. And I want you to give us a fact. Is that a fact or is that fiction? Now, they're probably all going to be there's exceptions to everything.
They're all going to be, it depends.
They're all going to be, it depends. But I want you to explain kind of which side of the argument you are in here. I'm going to start with the first one, which is very, very popular. Most jurors hate corporate defendants. They hate corporations. You hear that all over the place. You read this in articles. Why are nuclear verdicts happening? Well, it's jurors. They hate corporations. They absolutely hate them. What are your thoughts on this as a trial attorney?
I don't think that that's 100% true, and I don't think it's 100% false. Unfortunately, lawyers give...
Everybody hates lawyers.
I was going to say lawyers through their workup and defense of cases give jurors reasons to hate corporations. It comes down to making sure that you're not putting up a witness that's ill-suited, ill-prepared, or doesn't have a clue about what's going on. The reason that cases explode is not what just happens in the courtroom. It happens in the years before a case ever walks into a courtroom for jury selection. So, the atomic bomb wasn't built in a day. Same for a nuclear verdict.
Yeah, I think some jurors do not look upon corporate defendants very favorably, but actually many do. So I think that's mostly fiction. I think there's a portion out there, and you have to find those during jury selection, correct? But not everybody hates corporate America. That's just another convenient excuse for these nuclear verdicts that they like to jump to. So that's an example of the game we're going to play: flat fact or fiction. Okay, are you, Uncle Paulie? I like to call you Uncle Paulie.
Sure,
it's very Chicago-ish. Are you ready for the next one?
Bring it on.
Okay. The employee with the most experience should be the 30B6 corporate rep.
Fiction.
Yeah,
it can be true, but it's never cut and dry like that.
Because they may not be the best communicator, they may not be the best witness. So if you had a witness that was really good communicator but less experienced, you could train them up to be the corporate rep, versus you have someone say, hey, 30 years of experience, but they kind of suck as a witness. Which one would you prefer? I think,
anytime I can work in a reference to office space, I mean, Bob Slidell, is the people person and he can't communicate worth a darn. And then you get Peter, who's had this awakening, or we call it training, where he's now effectively communicating about the issues that are of the day. And that's what you want. And, it doesn't matter the jurisdiction, whether it's state or federal or which state it is, you can train up a corporate representative.
I agree.
And that's your responsibility to do regardless, and they pay us for it. So it's one of those things where, why are attorneys trying to take the easy route instead of identifying the best route and identifying a plan to achieve the best result possible?
See, do you like this game? I think it's the first time we've done this in the podcast. Okay. Fact or fiction. So you're the inaugural guest. I've call you the guinea pig if that's appropriate.
Wouldn't be the first time you've called me that.
Okay. Next, fact or fiction. Someone that's been deposed many times before is usually a good witness on subsequent depositions.
Fiction.
I totally agree. I think that witnesses that may have been deposed many times before have been pretty shitty many times before, and they carry over those bad habits and maybe even a little bit some overconfidence. What do you think?
Well, I would say this. I think I've said this on this very podcast before. A bad deposition is forever. And so,
If your corporate rep it is,
yeah,
ugh,
and or if you're an expert, or if you're
expert, yeah.
somebody that's just going to be ending up testifying a lot, yeah, they might understand it. Yeah, they're likely to know the ins and outs or the tricks that a plaintiff's lawyer or defense lawyer might want to play with them. But just having that experience, you know, I don't know. There's been bench warmers in all the major sports that have been to the Super Bowl, been to the NBA Finals,
Brock
been to
Purdy,
the,
Brock Purdy.
Hey, Brock Purdy's the starting quarterback now. I'm thinking of like the guy that backed up Peyton Manning.
Oh, that yeah.
Jim Sorgi, my
See,
associate
there you
here,
go.
extraordinaire, just brought that up. Jim
We have him here
Sorgi.
for backup statistics.
Yes. So I'd rather have the Peyton Manning or somebody that's actually played in the big game as opposed to someone that sat on a bench and held a clipboard during the big game, if that makes sense.
This is great stuff. All right, next topic, fact or fiction. Witnesses can win the case at deposition.
Fiction.
I mean, does that?
So technically, that can
Technically-
also be fact depending on the witness. Defense witnesses, I don't believe, can win a case at a deposition. They can absolutely lose a case. A plaintiff's or an independent fact witness or an expert, they can win a case or lose a case at a deposition. Absolutely the truth. And a plaintiff can also win a case at a deposition, though that's not as likely. But it's not a hard and fast rule. But problems are when somebody tries to win the case
Yeah.
at deposition, and then they just cause more problems.
Yeah, I think a good cross-examiner kind of likes a enthusiastic witness that wants to try to win because they're gonna be more vulnerable. They're gonna step into more traps. They're gonna open up the door to further attack and further cross-examination. It rarely works. I think if you're telling your witness to go out there and win the deposition, usually not a good move. Expert, perhaps different, right?
I don't want them to overreach. I want them
Yeah.
to do exactly, I want them to stay in their lane. I want them to be an expert. I don't want them to come off as too arrogant because they're the plaintiff, if they're videotaping, are going to find a way to get in some, unflattering video deposition testimony. It doesn't matter. It's not going to go well for you. So,
And we want things to go well.
exactly.
All right. Next topic, fact or fiction. Witnesses are more vulnerable during Zoom depositions. I think this is a great question because it's kind of a newer question. Newer technology.
I think it's absolutely a fact. Absolutely a fact.
And state your rationale, Console.
Very simply, there is something about Zoom or any video teleconferencing or even just doing it over the phone where it's a lot easier to make a mistake and miss the blatant signals that a defense lawyer or the defending lawyer or your plaintiff are trying to send. It's the easiest thing. I can't kick a witness under the table on Zoom.
Unless you're sitting next to them. I've seen several set up where the witness and defense attorney are together, but sometimes they're apart. But the plaintiff attorney is on Zoom.
I always show up
Yeah.
for a deposition, even if it's Zoom. The mistake, the reason to me, the reason that a witness is vulnerable is because the lawyer defending them is not present.
You got to get on the airplane or get in the car or whatever and be next to them. I also find that Zoom, I know this unfortunately from so much witness prep on Zoom, it melts your brain. It melts your brain.
So
and you fatigue. Yes, it is my excuse. You fatigue faster. You need more breaks. Do you think I've seen this. Do you think because of the lack of face-to-face interaction on Zoom sitting across the table that the witness is more vulnerable to kind of falling asleep behind the wheel, maybe get more comfort?
I think and it's absolutely true. I tried a Zoom trial back in the age of the pandemic.
I'm sorry to hear that.
But the thing I noticed, and the judge commented on it, now it was a bench trial, but everybody, including the judge, were far more informal than it would have been had it been in a more traditional setting. And I see that in Zoom as well.
Yeah.
So, I don't like the concept. If I can be in the room with the witness, whether I'm taking or defending, I'm going to be there. And I love it when my opponents don't show up.
I think also on Zoom, maybe a benefit. I think maybe the intimidation factor is a lot less since you're not sitting eye to eyeball away from the questioner. So maybe that would be a benefit. But there's certain challenges. I do think if you're going to have a Zoom deposition and you know it, you should do witness prep by Zoom as well. At least a couple sessions to
Sure.
get used to the medium because it's sometimes very very awkward. All right. Do you like this game? This is good. Fact or
I
fiction?
like games.
Okay, this is good. Um, Fact or fiction, you should prep your witnesses very close to the trial date so they don't forget the information you teach them.
Well,
Hmm.
let me ask a follow-up. Is that the only time you've prepped them?
Well, I think the theory here is, and I get this call a lot, they're like, well, let's set up the witness prep dates like the week before the trial. And my response to that is, well, what if we find something really, really bad? We only have a week or maybe even less. I would rather at least get kind of round one started 6 weeks before trial and kind of at least get the ball rolling and do this in a staged approach than cramming it all in. I mean, isn't the week before trial this chaos?
It is.
Motions,
It
it's nuts.
absolutely is chaos. But the caveat I would give to that answer is, no offense, Bill, I love hanging out with
Oh,
you.
here we go.
I don't need you at every witness prep session. So I like bringing you in as we are trying to, after the attorneys have, unearthed the diamond, it's still rough. We got an idea that it's a diamond and not, a piece of sap containing the DNA of
Yes.
a long dead dinosaur. But then we turn it over to you in the weeks leading up to trial or the months leading up to trial to start putting on that shine and really crafting the witness to be the best communicator possible. If you're waiting to the last week, you've made mistakes. Sometimes it happens, but the more time you can put in with a witness, the better they will testify at trial.
Now, again, now you're not under oath, counsel, but I would like to be honest here. Do you get pushback from clients, insurance companies when you want to start and invest time and money maybe into one of us at Courtroom Sciences? If you want to start that process early, do you ever get pressure from clients like, well, let's put it off. Let's put it off. The case may settle, and then the case doesn't settle, and then you're kind of stuck in this doing things last minute type of situation.
So I can thankfully say I have not, but I also handle more high exposure cases where the claims professional or the in-house counsel they understand the risk. I hear that all the time from primary level carriers or, SIR TPAs where they're trying to, be penny wise and pound foolish. Every time, I get in work with a new carrier or a new client, I'm telling them my approach to both witness preparation before a deposition and witness preparation prior to trial. And frankly, that is the witnesses will make or break your case. And so everybody has to be on the page that this is a worthwhile spend of time and resource.
I think I just earlier the better because if you find a problem, at least you have the opportunity to fix it. I think I think the other reason is that I'm assuming this is the same for you. Witnesses coming into dep prep versus trial prep. I think the anxiety is bad enough during dep prep.
Oh yeah.
They come into trial prep. A lot of them are basket cases. I mean, we're not like we're going to trial. We're going to be in front of a judge and a jury. People from the community may be there. It's emotional
And the
nightmare.
opposing counsel is the executioner.
Yeah, the executioner. Just absolutely, it can be brutal. So I think early is better. Um, this next one I think is kind of a no-brainer, but I'll ask it anyway. Fact or fiction? Plaintiff attorneys do more jury research, mock jury research than defense attorneys.
Fact. 100%
Yeah.
fact. They know how to do it. They know how to do it early. Often. The plaintiff's bar, I mean, they understand what drives cases and how to drive up the values of the cases. And so, my friends in the plaintiff's bar and the ones that I wouldn't ever consider having a beer with, they know how to, target these cases get those themes early and test those themes. And they'll not always spend the $100,000 on a mock trial. It might be an online focus group, or it might be just a little more, nothing more than, you hire 20 people off the street and say, hey, come look at this. But they know how to do it, and they know how to do it effectively.
And early.
And
I think
early.
that's the key.
Yeah. All these high dollar cases in the tort world are getting mocked and focus grouped by plaintiffs multiple times, multiple, some of them as much as 10 times before the case goes to verdict. I mean, it's impressive what they do.
Yeah, and there is a way to do it cost effectively. There is. So call us here at Courtroom Sciences, and we'll talk about that. We'll get a proposal out to you. Fact or fiction? The former employee is always the worst witness. I think this could go either way.
Can be the worst witness,
sure,
especially if they left on.
They got terminated.
Again, I always worry about cases where the key witnesses have been out of the company for years, because it's much harder to control them. It's much harder to have their buy-in in these cases. But for every time that I've had an absolute dumpster fire, I can give you cases where come into the former terminated employee or truck driver and have gotten them squared away to see, okay, this is, this involves your employer, but it really involves you and your conduct.
Your name.
And so this is about your reputation, and give them the opportunity to have buy-in.
Yeah.
And that's what's key.
Yeah, I absolutely agree. Some techniques to get them on your side is be nice.
That helps.
I've heard of many stories. I mean, how many times have you called a former employee to tell them about, depositions coming up, and they hang up on you, or they avoid you, or they don't answer? Yeah. So breaking.
But I've also, the thing that lawyers, it seems like, some lawyers just refuse to do is try and relate to a witness on a human level. I remember a case years ago, it was pre-pandemic, so that like decades ago now, where it was a former employee that got fired and was very bitter about it. And the lawyer that the firm that I ended up taking over from never went to go meet this guy in person. And I show up, say, hey, I want to come have a conversation with you. I'll either do it over lunch, or, I'll come to your house and I can sit in your living room. You can meet me. You can understand that I'm not some stuffed shirt. You got to have trust in all aspects.
No trust, no nothing.
Yeah. So that's how you get somebody squared away. Sometimes it's never going to work. But you have to make the effort, because your clients deserve to know early on, well before a deposition, and certainly before a trial, where the problems lie.
Absolutely. Okay, two more. Fact or fiction? Mock trials are superior to focus groups.
I believe that's fact.
And what's your rationale, counsel?
Because every focus group I've seen, it's much more truncated. It's not the same level of persuasion, and you're much more moderator dependent than in mock trials. It's clearly delineated. You've got a plaintiff arguing, you've got a defendant or defendants arguing. And I just think that forcing the jurors through that is much more structured and beneficial, not only for the overall client in determining what's good, what's bad, but it's the exercise for the lawyers is valuable, and the lawyers teams. Like I'm sitting here with my associate Stephen, getting him exposed in this process it's invaluable. I tell all partners out there, take your young associates to witness preps, to mock trials, to focus groups, to trial, and then to the bar.
Of course.
And maybe a pizza party too, as opposed to giving them a raise. But that's another thing. That
could be the rant for today. Think about that.
Yeah, there we go.
I would argue that early in the case, for case assessment, that the focus group would be superior to take a deep dive. It's a lot of juror interaction, but when you're for trial prep mode, I think that's where your mock trial is going to pay off the most. Okay, last one. Then we're getting to our football picks. This is Now by the time this is posted, it could be a couple weeks go by, but that's fine. We'll put out our predictions now. Okay, so let's see, last one. This is a fair answer. Now remember, it's 2024. Times have changed. Witnesses with tattoos and or piercings have their credibility hurt in front of a jury. I 10 years ago I'd say yeah. Now I know lawyers that have sleeves, and I've seen some. Ever like been in the Pacific Northwest and seen like
that's
like the jurors all have piercings and tattoos. I don't know if this is a big deal.
I
Maybe
think
it's venue specific.
that's exactly what I was going to say. It depends on the jurisdiction.
Here in Alabama and I mean Birmingham, I'm not. I don't know. What do you think?
Well, I'd have to ask our colleagues here to get
We'll get local counsel's opinion
Yeah.
tomorrow on that.
But it just
Seattle,
depends.
Washington.
I
I think it's probably going to be in the norm.
what I would say is that having them isn't necessarily a problem, but when you're a defendant and you're having either your client or your client's employees go before a jury, you want to give the 70-year-old Dana Carvey-esque church lady all the way down to the
Yeah.
millennial or Gen Z confidence in who they're talking to. And so obviously there are visual stigmas to certain generations that they can't get their heads around. So it's kind of just like trying to figure out how best to manage that risk. If somebody's got a facial piercing, you're not going to change that. But if they've got
Face tattoo.
face, okay, Mike Tyson.
Yeah. I mean,
But if they've got full sleeves, maybe
Cover 'em up.
You can cover some of them up. I mean, it's
have you seen some of these truck drivers, Paul?
yeah, I have.
I mean,
But
a lot of ink,
ultimately-
man. A lot of ink
so
sometimes.
ultimately, I don't want my witness to be uncomfortable up on the stand. And so if we are trying to cover up in parentheses or quotation marks, there we go, quotation marks, who this person is, the person's not going to be confident, and the jury's going to sense this is, there's an act going on here.
Yeah.
So, there's no hard and fast rule, but witness comfortability in their own skin, in my opinion, leads to better communication and trustworthiness of message.
Now, as trial counsel, would you wear like a nose ring, like during your opening, just to maybe bond with the jury? Say, okay, so you're trying a case, Pacific Northwest, younger jury, everybody's inked up, tatted up, and everybody's got piercings on the jury. Like, do you go down to the local piercing tattoo joint and get the nose ring?
I think the same
Is that no?
advice applies. If you are comfortable in your skin, you got to be you as a trial lawyer. And I can tell you, I would not be comfortable.
You're not doing that
with a nasal piercing, especially gotten the day before I picked a jury or open trial, because just the swelling alone would be uncomfortable.
Yeah. So let's so I think we're gonna our recommendation is going to be to avoid those.
Yes.
Avoid any type of facial
in the
things.
immediate 72 hours before
after the verdict. Do whatever you want. Okay, let's go to our we're going to go very quickly. College football Final Four. Now, if you'd like to think, I'll go first.
Okay, you can go first.
I'm going to go. I think UGA, the Georgia Bulldogs, are so pissed off from last year. I think there's going to destroy everything in front of them, and they're absolutely getting the #1 seed in the playoff. Number 2, and I hate to say this, I got to say it, but boy, they look good in the opening week. I think Notre Dame looks solid. I mean, he's already shaking his head over here. I don't need this feedback from the peanut gallery. Tell your associate to shut up while I'm doing this podcast. Notre Dame is really good. They got huge.
I agree with you 100%.
And I think Notre Dame's is gonna get in there. Third, I'm gonna go with another really pissed off team. The Ohio State Buckeyes. They're upset from last year, got embarrassed. I got embarrassed a couple times in a row by Michigan, the cheaters. That's a whole separate podcast with the Michigan cheaters. But I think Ohio State is going to secure a spot in that top 4. And then finally, now I'm going to go, because I think Alabama's going to take a couple years to get back. New coach. Ready for this? I'm going to go Lane Kiffin and Ole Miss sneaking into the number 4 spot. Polly, what's your Final 4?
Definitely not Notre Dame.
Okay, I ask you what it's not your final. I ask you what your final
spot on with his judgment of you.
No love here on the litigation psychology podcast.
I think I'd agree with you about Georgia. I think they're definitely in. I don't know if I'm willing to say they're going to be the number one seed.
Tough for it. Doesn't matter.
The Ohio State University, definitely. Uh, this weekend, as we were approaching
Is
the
Florida State on your list and now they're not?
no, but I think what's going to be very interesting is to see the outcome of the Michigan-Texas game.
Yes,
because I want to put Texas in this list because I
to.
think they are back. So
They got them last year.
I'm going to put them in there.
The Longhorns.
Yeah, hook them.
That's a rough. It's their first year in the SEC.
Hey,
You know, they're gonna get beat. Oh man, it's gonna be. I think
Hey,
you're looking at a 3-loss Texas team, is what I'm telling you right now.
I'm
throwing it out there right now.
You may
Laying
be,
down the gauntlet.
you may be right.
Okay.
And I'm trying to think where the fourth team comes from.
It's got to be an SEC team, right? Unless you're going like Boise State or
Georgia.
Utah.
Did I say Alabama?
No, you did not.
Oh yeah, Alabama. I think they're back.
You think they're back already?
I think they're back.
First year coach.
I think so.
Guy left Washington. He's going to turn it around that quickly.
Yeah, I think it's going to be Bama, Georgia, Texas, and what was the other one? The Ohio State.
The Ohio State University. Okay, well we have this on record. Now let's go to the big one. Okay.
Drum roll, please.
Super Bowl.
Oh no! Come on.
Now this time you're going to go first. And at first, I'd like you to start with the NFC representative and then your AFC representative. And by the way, I'm going to take UGA as my champion in that college football. What do you think?
I think it's going to be either Texas or the Ohio
You've
State
got this
University.
what is going on with this Texas thing?
Broken clocks. If I keep picking it,
I know.
I'm liable to get it sooner or later.
Blind squirrel gets a nut. Okay,
Yep.
I'm going UGA. All right. Who is going to be the NFC? This is brutal. This is NFC representative.
I think the NFC is absolutely stacked again.
And wide open.
I think it's going to be interesting who comes out of the NFC North. I think you'll see multiple teams get into the playoffs from the NFC North. Go Bears.
Okay, that's okay. Your NFC North bias is really coming out here.
But I think right now we know the Cowboys will choke.
Just don't say Green Bay. Please don't say.
Oh, I would never say Green Bay because I think that they're not as good as the San Francisco 49ers. And that's who I think is the
they had some off-season turmoil. They completely shit the bed in the Super Bowl in the second half last year. You're thinking they're coming back to redemption tour?
I think they're coming back.
Okay.
So the redemption, they're in their redemption era.
They're in the redemption era. Okay, I'll take that. A little off-season contract stuff.
Every team, yeah, but they got
their wide receiver just got shot in the chest in broad daylight.
But their main wide receiver just got.
It's a bad omen, dude.
A huge.
Okay, go with your San Francisco. 49ers. And who's going to represent the AFC?
It's one of those things.
Don't say it.
If it ain't broke,
don't.
It ain't going anywhere. As much as I don't want to pick the Chiefs, I think it's between them and I could see it three ways: the Chiefs, the Texans, or Baltimore. I just don't think Baltimore's offense is good enough.
Yeah.
I really think,
get there, but they can't finish the job.
Yeah, and Lamar's going to get injured again at some point. Patrick Mahomes is out of this world, and that
it's fixed. It's rigged for these guys.
Yeah,
the whole thing's rigged.
We want to see Taylor Swift propose to Jason Kelsey Travis Kelsey after he wins the Super Bowl.
I don't know if I can handle this again
in 2025. So there's my pick. I think the Chiefs are going for the three-peat.
Chiefs in the three-peat. I am going to say something that's going to cause. This is going to be worse than my Notre Dame pick. I am going Dallas Cowboys to finally break out. You can't screw up. They're going to figure it out. I think I pick them every year of the podcast so far. It's been highly humiliating, but
entertaining for us.
I'm sticking with the Dallas Cowboys. They're going to get fixed. Prescott in a contract year. Let's go Dallas. And yes, I do think that they're going to play the Chiefs again. No one's beating the Chiefs in the AFC. Sorry, not going to happen. So you got Cowboys, Chiefs in the Super Bowl, and I'm going to say it right now. I'm going upset of the century. The Dallas Cowboys finally, in the first time in 25 years, bring home the trophy back to Arlington, Texas, and to Jerry World. And this face that you're making right now, I'm glad we're not on camera because God, this is really, really bad. Everybody's laughing at me.
I mean,
we're on the patio here at the Grand Bohemian, and in Birmingham, and I'm getting humiliated here.
Well, hey, you make a bad pick.
I think it's
You're making a pick that the team can't cash. I mean,
this one, they're a dark horse. No one's expecting it, which is why they're going to do it.
oh, their fans are expecting it. They're as delusional as those Notre Dame fans.
Oh boy.
You know,
So I'm getting double trouble from this.
well, here, let me ask you this question. What's the Bears' record at the end of the season? And do they make the playoffs?
The Bears record at the end of the season will be 10-7. I think they're a 10-win team. I think they have the potential to get that to 12 if their kicker doesn't be doinking field goals and based on their offensive line. I think the ceiling, I tell you what, the Bears ceiling, I think, is 12 wins. That would be exceptional for a rookie quarterback. I think their floor is 8. So I'm going to that 8 to 12 range. I'm going to settle at 10. But I really think next year for the Bears, with a quarterback with more experience, quarterbacks make the most progress from year 1 to year 2. I think that's going to be when they'll shine. But I tell you what,
Bears don't really have a history of year 1 to year 2 quarterback development.
No. Well, except for the awesome Mitchell Trubisky, who was fantastic in year 2, and then
fantastic
they
Bears
ran him into the
quarterback.
ground. They ran him into the ground.
Like saying
this is completely off the rails.
You don't even want. I can't even put the analogy on the record. So to answer my own question, 11-6, they will go to the playoff, and they will lose in the first round.
Outstanding. Okay. Well, thank you very much, Paul, for coming on the show again. I believe it's your third time on the show.
Third or fourth.
Yeah. I think that would put you as the number one most frequent guest. We have to keep that up because I want to do some more panel discussions.
Sure.
I want to get that going before the end of the year. And to all of our listeners, thank you very much. We love the podcast and we love talking to you guys. Hope you enjoy it. Litigation Psychology Podcast brought to you by Courtroom Sciences. We'll see you next time.